the very first document that we're going to talk about is a will. Wills are, it's essentially your ability to write down who you want to leave your possessions to. That's essentially what a will is. A will does not take effect until after a person passes away. There are other ways for them to protect their assets while they're still alive. Sometimes that might be a power of attorney, or in case of like medical directives, it might be a healthcare proxy, whatever. But please understand, a will does not come into actuality or does not become real until after a person passes away. That is the first and most important part of a will. The person who makes the will is usually called the testator, all right? To make a will valid, a person must possess the mental/legal capacity, we just talked about that, to know what he or she is doing. That's number one. Number two, the person must have a level of awareness to understand the essential elements in the will. This is more of a capacity test. Can they understand the names of the people that they're leaving things to? Can they understand what date it is? Do they understand the places or the items of importance? Essentially, do they understand that they're leaving their house to their cat, Fluffy? And I'm saying that in kind of a lighthearted way because this stuff can be really, really intense and very, very stressful. So I try and have a little bit of fun with it so that people can not stress too much and people relate to it a little bit. But please understand, these are serious topics. Hopefully the lighthearted example, though, will help people understand what we're talking about. And as I said, the person's mental state must be verifiable. Usually that is done by having a witness there or the attorney drafting the document also having to sign it, or a witness having to sign it, or a person having to notarize it. Those are sort of checks and balances to make sure that the person has the mental capacity when they create the will. Let's go on. We want to plan ahead. Executing advanced directives allows a person to maintain control of decision-making. It's the best and most effective way to express your desires and influence decisions relevant to you. Listen, what that really means is this. When you put together a legal document, you have control of what you want done, how you want it done, what is most important to you. If you do not do this, the risk is that someone else will decide how your assets are allocated, or what medical decisions will be made for you, or what will be done in terms of end-of-life decision-making. You want to make those decisions for yourself if you have the desire to. And I think most people do, from my experience. So that's what we're really talking about here. And this amazes me, but when last checked, almost 70% of people do not have wills, or at least they think they do not have wills. Everyone has a will. Let me explain what I mean by that. If you do not create a will for yourself, every state in the United States of America has an ordered procedure of how to distribute your assets amongst your family. Okay, every single one. So if you don't create a will telling the state how you want your assets allocated to people you leave behind, then they will go along the checklist that they have, and that's how they'll do it. So in effect, everyone has a will. You just may not have the will that you want.